It's my great pleasure to welcome to Duke University, on behalf of the Law School and the Center for International and Comparative Law, Professor Beth Simmons, who is the Clarence Diller Professor of International Affairs at Harvard University and the Director of the Weatherhead Center for International Affairs there. I've known Beth for a number of years and have, as I imagine many of you have read her very interesting and diverse and extensive body of work on issues including institutional design, regime theory, compliance with international agreements, international trade and investment, and of course, international human rights. And just sort of one personal anecdote, I think Beth has succeeded perhaps better than any other scholar to bridge questions that are of interest to international lawyers and international legal scholars and international relations theorists. And she speaks to both of those academic communities, and she does so using a range of really interesting and careful empirical tools that allow her to really say something about how international law works or doesn't work, what sorts of state behavior are affected by international agreements and international institutions. And to me, that is one of the most important questions. And so her work, in particular on human rights, over the last several years, as now encapsulated in her new book, Mobilizing for Human Rights, is really quite tremendous. I have my own copy, which is now getting dog-eared already, and already has, as you can see, kind of tags and so forth for other things that I want to call back and look at over the coming months. So I really do urge you, if you haven't read the book, to consider purchasing a copy outside. We'll have a book signing when the Beth's talk and questions are concluded, which will be promptly at 1:15. So I'd certainly urge you to stay around for that. And Beth has asked me to say that she's going to be giving a presentation, but she welcomes questions and interruptions as she's going forward if you have issues that you'd like to raise, so we can have more of a dialogue. So without any further delay, please join me in welcoming Beth Simmons.
Thank you very much, Larry. I appreciate that introduction. And the topic I'm going to be dealing with today is a topic about which almost everybody I've met has an opinion. And it turns out that opinions are very, very hard to shift in this area. International relations scholars come to this question of the influence and effect of treaties in a very skeptical mode. They come to it thinking that treaties don't affect activities that are important or critical, especially in international relations, and to the extent that they think about domestic politics, they would draw very similar conclusions. Legal scholars often come from a different perspective, thinking that once we understand the content and the doctrine of treaties, we can kind of stop there, because treaties, of course, matter, and treaties are, of course, important instruments in order behavior. So it turns out everybody's got an opinion. And it turns out that when I began this project, there was very little systematic research on the question. That systematic research has really only taken off in the last, I would say, 5 to 7 years to look at the nature of this question. I chose an area to look at the effect of treaties in one of the most, I think, difficult areas to do so, and that is the area of human rights. Because if you think about it, of all the areas that states can create treaties between themselves, this is a very non-reciprocal area. We know why states sign trade agreements. It's to enjoy the mutual benefits of trade. We know why they sign security agreements. It's because they want to enjoy the mutual benefits of security, and they expect behavior of a contracting partner to change in order for that outcome to be the case. Now, with human rights, it's simply not the case. I'm not going to affect my human rights behavior simply because another state has done so. And concomitantly, if I simply want to improve human rights in my jurisdiction, I have lots of domestic ways to do that. So it's a little bit more of a puzzling area for international law, why we even have these regimes in the first place, and certainly why they might have purchase over how states actually treat their domestic citizens. So the questions that animate this project really are two. Why do states ratify human rights treaties? And secondly, do ratified treaties impact human rights practices? And if so, how do they do this? Now, this project focuses on a broad range of issue areas, and in 45 minutes or 40 minutes, we can only really pick and choose a few themes here. But just to give you sort of a sense, it begins with an introductory history, because while we can focus on the question of why do states ratify a particular treaty, we have to think historically to know why the entire human rights regime exists at all. And of course, it grows out of the experience of the Second World War. It grows out of the scourge of fascism and important groups that felt it was quite important post-World War II to include the governments of the major powers to address human rights in the post-World War II peace arrangements. The second part, though, deals with the question of the theories of why would any state, now, given that a treaty is ratified, given that a treaty has been negotiated, why would a state then decide as a matter of a sovereign decision to ratify that treaty or not? The third part focuses on the behavioral outcomes of so doing. And it looks at the area of civil rights, looking at the International Covenant on Civil and Political Rights. It looks at women's rights. Humane treatment, that is the Torture Convention, is the focus of that chapter. And then the Convention on the Rights of the Child, protecting and giving rights to children. Each one of these chapters has a quantitative component to them. The kind of evidence that I bring to bear in this research project is a combination of case studies as well as quantitative statistical analyses that tries to isolate the effects of having ratified a treaty on behaviors we might care about. And each one of these chapters has at least, has from between 1 to 3 indicators of compliance or behavioral change that we would expect to be associated with the ratification of those treaties. So the treaties that I focus on in the first part of the book are what people sometimes refer to as 6 core human rights treaties. They were negotiated from the 1950s and begin to be open for ratification in 1966, beginning with civil and political rights, economic, social, and cultural rights, Convention on the Elimination of All Forms of Racial Discrimination, discrimination against women, Convention against torture, and then Convention on the Rights of the Child. All of these treaties have in common that they're universal in their aspirations, so they are not regional, they're not European or American, they aspire to be global. Each one of these treaties was under the auspices of the United Nations, a global participatory process, and each of these treaties also contains something of an oversight committee, a committee which is empowered to receive reports from the governments that are parties to the treaty, and in addition, optionally, as a separate agreement to each of these treaties, to listen to, and this varies actually by treaty, but to also receive complaints by individuals about a state's behavior with respect to treaty compliance. So they're comparable in some sense. Well, an interesting sort of thing to ask is why would states ratify these treaties at all? If you want to improve children's rights, why not improve children's rights? And so why would you do this? And some people argue that it's costless and symbolic. Well, if it's costless, that is, you don't expect any costly change to be attendant to ratifying these treaties, and if it's only symbolic, why would you see the following patterns? What you can see here, and this is just total ratifications on the vertical axis, so that's a cumulative number of ratifications for each treaty, and you have years here. And you can notice some really interesting differences across these treaties. Now, if it was just costless to ratify all treaties, you would expect the patterns to be identical or very, very similar. It is not the case. So one thing we can notice, for example, is that the Torture Convention has the fewest adherents. We can notice, too, that the Children's Convention is the second one down, the bright purple, has the most and got them very, very quickly. There is something different between the pattern of ratifications for the Children's Convention and the Torture Convention. And you can imagine what could be behind that. On the one hand, children are harmless creatures. They are creatures that we want to protect sort of almost instinctively. Granting them rights is a little bit more problematic, perhaps. But it seems like politically a fairly costless kind of move to make compared to the Torture Convention, which is non-derogable, and as well could very well provide protections to political opponents of the state and pose other potential security risks to the state if it is indeed abided by. So there are differences between these treaties, and if it was just costless, you wouldn't see these differences in patterns over time. You can also see differences in pattern by region of the world, which also raises questions about why. Why would Eastern Europe and Western Europe, FSU, former Soviet Union, why would those be the regions that ratify these treaties much more frequently than, for example, Asia and the Pacific, which has a much, much lower ratification rate? There is something systematic going on that simply to say ratification is costless does not address. And that, I think, helps to pose a very interesting puzzle. So why commit? Why would governments commit themselves to a treaty that influences their relationship, or governs, shall we say, their relationship to their own domestic audience? And I performed a little experiment one time when I was giving a talk. And this experiment was done at the University of Illinois when I gave a talk to about 200 students. And as they filed in the door, I handed each student a little slip of paper that, if you looked at it quickly, all looked identical, okay? If you really compared them, you could see some differences. And the paper said this, half a sheet of paper. It said, there is currently a debate about whether the United States should tighten rules for interrogating detainees, limiting psychological forms of abuse. Everybody got that statement. Half of them got what is in italices inserted into their little paragraph. Half of them got this treatment. This is a treatment because it's an experiment. These forms of abuse are outlawed by the Convention Against Torture, which the United States has ratified. Half the group got that randomly. Everybody got, do you think the US should follow rules limiting psychological forms of detainee abuse, even if it makes it more difficult to collect intelligence information from them? Okay, so you can see what I did here. Without the authorization of the Human Subjects Board, I performed, don't tell on me about that. I performed an experiment on students coming in the room, and half of them received a treatment, and I'll call that the law treatment. The knowledge that the United States ratified, and we're bound by it, okay? And it outlaws that behavior. So this is what happens for the group that does not receive the law treatment. 47% say yes, that the United States should limit psychological forms of detainee abuse, even if it makes it more difficult to collect intelligence information. Now, what do you suppose happens to these proportions to the group that received the italicized word? Any guesses? Okay, because they've been given the suggestion that a law exists and that the United States is bound by it, okay, and that the behavior in question is not consistent with the obligation. All right, so that's good. Anybody want to guess by how much?
I'd say it absorbs most of the possibilities.
Okay, so you think it's going to be closer to 80% maybe? It's a big number. Okay, so, but quite at your maybe between sort of 60 and 80 or something like that? Okay. It doesn't go quite that much, but this is exactly what does happen. You get 62% saying yes. You get 29% who said possibly. And what you really get is a reduction in those who say no. Okay, so that's, now these are fairly, this is not a nationwide sample. It concentrates on college students, college sophomores, juniors, but it was administered randomly. That is, whoever got the treatment was a random draw. Well, it raises some interesting questions. It raises questions about why does something different happen when you have a ratified treaty? Why do people think differently about it? Now, nothing in my book plumbs these questions of psychological effects. Instead, I sort of think of what the aggregate consequences might be for a society or society-wide if these kinds of effects could be generalized, which I have no proof that they are. Yes. Yes.
I think you would acknowledge a lot could change if you just change the wording. So
yeah.
Imagine I put in, if we tightened up, we're likely to have more terrorist incidents, but bureaucrats in the UN will complain under this thing they call the convention. I can imagine that changing. So.
You bet. If you said something like, would you agree if you thought, if there was evidence that this would increase terrorist incidents, that number would go down? I'm guessing. I'm agreeing with you completely. Right. No, if you suggest danger, if you suggest a security risk, you will get a difference here. I would hypothesize. Now, one could do some really interesting nationwide or even comparative national research on this question. There's no reason, for example, that Canadians would view this the same as Americans. There's no reason to think that Norwegians would view it the same, or the Japanese would view it the same, or Indians would view it the same. So that's exactly the direction forward in this kind of empirical research. The direction forward is to put precisely those kinds of alterations in and to begin to make comparisons cross-nationally as well. Yes?
What about which population of college students you're asking? If you tell me the university, I can tell you, right?
University of Illinois, Champaign-Urbana.
Okay.
What do you
Yeah, not so certain. But if you tell me Harvard, right, and you tell me, say, the University of Alabama, right, you may get a different, you may get a significantly different response.
You might. It might be somewhere different. You could hypothesize that there would be a difference between a university that primarily enrolls more liberal undergraduates than one that enrolls conservative undergraduates, for example. Actually, I did ask them what their party identity was on this, and there was a correlation between being Republican and being in the possibly and the no categories. So there's a lot of interesting work that really could be done on this question. I just threw this up so that even though it's not a nationwide sample, and even though we can imagine lots of differences, to just problematize this assumption that's out there that law makes no difference. And I might even want to point to some work that's being done by Michael Toms at Stanford that is trying to plumb these a little bit more nuanced and more scientific in the sense of being a lot larger surveys that are quite similar in many ways to this. Tim.
I don't want to sidetrack you too much on this particular little thing, but it seems to me the really interesting question is, does the treatment effect somehow go away when you look among the Republicans, when you look among people from a particular region of the country? I suspect not. Yeah,
I suspect not too, right. But it does have and again, I didn't run a multiple regression on this, but it does, there are differences between Democrat and Republican on this question as well. Self-identified, yes.
I guess I'm not concerned with that because you're not trying to make the point about this being representative. I'm more concerned that even your point about how a law treatment is affected very strongly, I believe, by the choice of words you've made in the question. You've characterized what the behavior is as abuse.
Right.
And right there you're saying, this is wrong. There's no question it's wrong. So now the only question is that you're trying to study is, does having a treaty about it make it less desirable for us to do this wrong thing?
Good. What if we change the word to pressure?
Yeah, exactly.
Yeah, good. And if one were to do a serious study where this was the core of what you were trying to do, that's exactly the direction you would need to go. Are we getting the effect from, although everybody got abuse, right? Everybody, that's a common treatment.
That's the point. Everybody got abuse.
Yeah.
So everybody's already told this behavior is wrong. Now the only question is some kind of, if it's wrong and there's a treaty against it, will more people say yes?
So my thinking was that if we put the italicized word as the treatment, that is something above and beyond the word abuse. But it does bear looking into, if you use the word pressure, for example, would you get the same results? Good. I just wanted to problematize that because that's actually not in the book. What instead is in the book is more a look at how states act in the aggregate, not how individuals sort of think. So I think that the question really is that centers the look into this treaty commitment in Chapter 3 of the book is that given a draft, what explains states' commitments? Okay. Well, states are, of course, an aggregation of their population, but it filters through domestic institutions, of course, and it also, their choices will be influenced potentially from outside factors as well. So we can think of two kinds of states in terms of ideal types, ones that we would expect to comply with a human rights agreement, that is, maybe democratic states, ones that support the treaty, they believe in its contents, they already treat women well, they already attend to economic, social, and cultural rights of individuals. And for those states, we would expect them to ratify, and they have preferences that match with the treaty. There's nothing mysterious about what we might expect here. We would expect Norway to ratify the International Covenant on Economic, Social, and Cultural Rights. They already do economic, social, and cultural rights in Norway. Those I call the sincere ratifiers. Nothing mysterious there at all. This group is also not very mysterious here. This is the group that you would never expect to comply, that they don't ratify, they stay outside of the treaty arrangement, and they don't change their behavior. They say, no, we're not interested. For whatever set of reasons, whether it's because they don't believe in women's rights, whether they are concerned about too many and too broad and legally protected civil and political rights, they don't want to go there. And those are ones who I call sincere non-ratifiers. Here, there's a preference mismatch. They anticipate, were they to really try to comply with the treaty, they would have to make a lot of serious changes that would be costly. So they decide to remain outside the treaty arrangement. These are the two groups here that really create some interesting puzzles for this question of ratification. There are some states that you might expect to comply with the bulk of the provisions of a treaty, yet they don't do it. And it's an interesting question as to why not. And I think one good example of this would be the state that we are sitting in right now, the United States of America, which has not ratified, for example, the Convention on the Elimination of Discrimination Against Women. But I can just give you my personal view as a woman. I don't feel especially discriminated against in this country and reasonably well protected by laws that give me equal treatment to my sort of male colleagues. So those countries are ones that we would expect to comply, but they stay outside the treaty regime. I call those false negatives in the book. That is, these are countries that you would have expected to participate. They don't, and we need to try to theorize why that would be. And here I think it really is crucial to look at the nature of domestic institutions. And three that I look at in particular that seem to me to help to create resistance to the prospect of ratifying an international human rights agreement are those relating to the ratification rules of the country. So in the United States, it is a very high hurdle to require 2/3 of the Senate in order to ratify the treaty. In most countries, the modal country in the world actually only can ratify with a simple majority. And then there are variations. And I was surprised to learn, I guess I just hadn't thought about it much, that in the Westminster model, the British system, you don't even need a parliamentary vote. Instead, it is typically read before the parliament, and there's some discussion, and then the government decides whether or not to ratify, thinking about the nature of their relationship with the parliament into the future. So ratification rules, the higher the hurdle, the more you would expect there to be resistance, even if the preferences are fairly similar. Federalism could be in the same way, actually. And again, we're sitting in a country in which many of the things that are governed by international treaties are actually regulated by the states, the subunits of the country. And so now you've got to think about what kind of political capital does it take for the central government, a government that may want to, let's say, sign the optional protocol to the International Covenant on Civil and Political Rights to end the death penalty, but now has to negotiate with Texas and Virginia and Arizona and several other states that feel pretty strongly that we're not going to go there. And so that takes a lot of political capital when areas of these treaties are actually under the legal control of subunits. And then finally, and this, all that may seem sort of obvious, but this last one may not. And this might, in some ways, is the more interesting argument here. And that is that there may be differences in legal systems, too. There may be differences between cases in which you have a very strong and independent judiciary and cases that develop their legal thinking and their legal doctrines based on a very ground-up approach to rule creation. Okay? So I'm thinking that there may be a strong difference between, for example, common law countries, which are characterized by maybe several things, but two of the key things that distinguishes them from civil law countries is that they give judges very, very strong and independent kind of decision-making authority. That is, they are viewed as sometimes as coming very close to the line of law making rather than law interpreting, and certainly have the right to interpret, but maybe even up to that possibility of fashioning law or creating law in some ways as well, compared to the civil law case where the term they typically use is we apply law. Law can be discovered and we apply it in this case, okay? And so there's a big difference between these two kinds of models. And I would argue that in a common law system, it's much more costly for a government to agree to ratify a treaty. And I'll give you two reasons why, relating to these differences between common and civil law. The first has to do more with the mode of legal reasoning in common law settings. So legal reasoning in the common law setting is inductive. It's organic. It begins with a case, a social conflict that happened in our local jurisdiction with our local people. And we conceive of lawmaking as settling cases of conflict as they come up. Precedent begins to be formed. We apply precedent. But it always is because we had this issue locally and we found ways to address it. That is inductive, from the specific to the general rule. The mode of legal thinking in a civil law country is the opposite. We can discover general principle. We can discover general principle, and we can find that in the code or in the statute, or in this case, in the treaty, and we can take that general principle and apply it in a case of local conflict. That is a deductive way to think about law. And I would argue that a treaty is much more in the second model than the first. And incidentally, I think this is why common law systems tend to be dualist. And we can go into this if you want to, but they tend to be dualist because they don't like general principles coming in from the outside and bombarding their local way of settling problems, their inductive mode of legal decision making. That's one reason. The second reason I think it's more costly in common law settings to ratify is because, picture yourself now as the government, who might be on the end of a lawsuit that you have not complied with your obligations under the International Covenant on Civil and Political Rights. You are likely to be the object of that lawsuit, okay? Now, think about the legal system in which you're situated. In a common law setting, judges are very powerful. Judges have a lot of discretion, have the ability with wide interpretive capacity and authority compared to civil law countries. And so in a common law setting, if you're the government, you have to worry about how that treaty will be interpreted in your legal setting. So if you're a common law government, let's look at, you face a different ex ante estimated probability that your courts will make a particular decision in a case in which you might be the defendant, okay? So what we have here is just an illustration of that. There may be 7 ways to interpret a treaty. There may be 7 ways. There may be more, many more. There may not be that many. But illustratively, there may be 7 ways, possible treaty interpretations. And if I'm a government and I'm trying to think, what are the courts going to do? I haven't ratified yet, but what are the courts going to do with this treaty? If I'm in the common law setting, I have a very broad dispersion of what they may do. There's a good chance they could choose number 7. There's a good chance they could choose number 1. The tails of the distribution are fatter. In the civil law setting, there's more of a peaked distribution. That is, ex ante, I can't be sure what they'll do, but I have a much higher estimated probability that it's going to be between 3 and 5. And I can be almost sure it's going to be somewhere between 3 and 5. And so that's why governments in a common law setting have a strong incentive to be very cautious about treaties. So those are 2 reasons which I think give interesting explanations potentially for why in a common law setting you get some resistance to ratifying human rights treaties. And in fact, these are the countries that I code when I do the empirical work as the common law countries. They're the same colors: Australia, Canada, India, the kind of salmon color there, okay? So those are the common law countries. We can see them in every continent with the exception of the continent of South America, but they are in the Caribbean to a very large extent as well. Yes?
Is there work, maybe it's in your book, has anyone studied whether in fact common law courts have a much broader range of treaty interpretations than civil law courts?
I don't know the answer to that. That's an interesting question. That would be That might be one result that you would expect if this argument is true, except that if my argument's true that governments are cautious, they've already narrowed it down. The other thing they've already done, and this is something that was very interesting empirical finding in the book too, is that common law countries enter more reservations of every kind. And that is very consistent with this argument. They are so worried about what the courts might do that they make sure they clarify. These are our understandings. These are our reservations. We will not go there. We mean it to be this. And they are much more careful with their reservations than are the civil law countries. So what we find overall is what I find in this, and I was very surprised to find this, is a very strong common law effect. And that is being common law is a negative drag on your propensity to ratify human rights treaties. Yes.
Firstly, I would predict that in the Latin American countries, where the force of the treaty as law is extremely high, that you would have some impact on compliance that ought to be demonstrably different or greater or somehow set off from the other, because
you think compliance should be higher in Latin America than elsewhere?
At least judicial recognition of the obligation to deal with this is very high. And not just brush it aside.
Yep.
And I would look for some kind of different normative effect of the treaty once it gets in.
I think you'll see there is. But I don't call it the Latin America effect. And I don't even call it a civil law effect. Instead, what I call it is an effect that's associated with being a country that is recently, or is in the process of transitioning, not a completely consolidated democracy. And I'll explain that in just a moment. We're about to get there. Yeah.
I have 2 points to make, being someone from Quebec.
From
Quebec, which is civil law jurisdiction for the most part.
Yeah.
And the province of Quebec, if they could, would ratify every single thing out there for another reason, because they want to show that they have international personality. So it's a confounding factor.
Yeah.
But also on the interpretation of civil law, if I remember from my civil law training at all, I agree with you. I think it's more hierarchical in civil law. The rules of interpretation are more clearly spelled out as a hierarchy rather than having equal validity. So I think it kind of fits with what you said.
I always thought Canada would be an interesting place to actually test this, to see whether there are systematic differences, see if you could somehow control for nationalism somehow, I don't know, but to see differences within a country, depending on sort of where you got your legal education and what kind of jurisdiction you are practicing in, would be very, very interesting. Time is so short. I thought it would be really interesting to do like a survey and to give it to entering LLMs or SJDs or whoever comes in with some legal training. Who comes in? Okay. And ask them what country they're from. Did they get a common or a civil law? And then just ask them things about their attitude about inductive versus deductive, their attitude about human rights treaties, and just see if you kind of see it at that level of the individual as well. It'd be very, very interesting. So many interesting things to do and so little time to actually do them in. This is just exactly what I mentioned about the reservations, basically. It just reemphasizes this. I read every reservation to every treaty. I put them in categories about what kind of reservation. They're not all the same, of course. And what I find is that common law countries are more likely to make reservations of every kind. Broad reservations like none of this is self-executing. That would be a broad reservation. Narrow reservations about capacity. We can't do it because we can't supply everybody a lawyer because we don't have enough lawyers in our country. Things like that. And enforcement reducing kinds of reservations as well, with one exception, and this is not surprising at all: reservations that refer to the civil code, which that's the way that civil law countries do it. All right, so the findings basically on ratification, that the more democratic a country, the more likely they are to ratify human rights treaties. All this can be demonstrated with pretty strong statistical results. Not uniformly, though, I should say. There's much more nuance than what I'm able to give you right here. But basically, this is the thrust, that the strongest and the most consistent explanation for the false negatives is actually the common law variable, which I'm surprised that it was that strong. And it bears more probing. This is not the last word at all on this common law variable. And then finally, the most consistent explanation for the false positives is what I call strategic ratification. And this is a variable that I used that that the density of ratifications in your own region influences your propensity to ratify. And that's because everybody else starts to look better for having ratified, and you think, I had better do so as well, or I will be subject to the criticism of the non-governmental organizations, the United Nations, the Europeans. The US is usually not one who goes around criticizing about this, but the Europeans do, for example. Did you have a question? Yeah, Bill? So I use the polity scale. Yeah. I use the polity scale in two ways. I use the everybody familiar with the polity scale? Okay, it's a scale that ranges from -10 to 10, looking at characteristics of a country that sort of indicate participatory and competitive democracy. Okay, so things like, are there constraints on the executive? Can people compete for office? That type of thing. I use that as a continuous scale, and then in addition what I do is I take countries and put them in categories, like have you been a stable democracy since World War I? Have you been a stable democracy since World War II? Have you never, ever been in the democratic range during any time during your independence? And then everybody else. Have you floated around? Have you moved up? Have you moved down? Those are the countries that I call being in transition. So I kind of try it both ways, and it's a pretty strong result either way you look at it there. But I should say, because you asked the question, it's strongest for the first 3 or 4 of those treaties in time, and it wears off over time. That is, for the Children's Convention, it's not as strong. And for the Women's Convention, it's not as strong either. It's still there, but not as convincingly. So why do states ratify then? It reflects genuine preferences, first of all. It also reflects these domestic institutional hurdles, and it reflects external strategic behavior producing some false positives. And I will argue that the biggest effects to treaties are going to happen in the latter category here. Those who acted strategically and found out that, surprise, it's got some effect. Because people start demanding that you comply with your obligations. So this last accounts for the bulk of the consequences for having ratified treaties, this group right here. So what does it matter? What are the implications? Treaties should have their most radical effects where ratification was, in fact, strategic, where there's the greatest potential to change the trajectory of domestic rights politics. And I argue this is not going to be the stable democracies. They're going to be in the sincere ratifiers category, and it's not going to be the stable autocracies. It's going to be the countries that, drifting around a little bit more in the middle, okay? And I'll give you a better argument for that in just a moment. So how do treaties influence domestic politics? And I concentrate on 3 ways, but there very well may be more. The first way really is in the sincere ratifiers. Treaties are exogenous to most states, right? Exogenous in the sense that my national agenda doesn't perfectly parallel the international agenda. My legislative agenda is precisely the UN agenda. Okay, so they're exogenous in the sense that I am one country out of 180, and I can't help it if the United Nations decided that they need an optional protocol on child soldiers. That's not what we were going to do this week, but now it's there and we need to respond to it somehow. It creates a new agenda item for some countries, okay? And so cases where this was important was the case of the Convention on the Elimination of Discrimination Against Women in Japan, where equal opportunity for women was hardly what they wanted to do in the early 80s. But they did want to participate in ratification and being among the initial ratifiers for the treaty, and having done so, they had to change or address their equal employment opportunity law. They had to do that, or they could not even be even a minimally credible ratifier of this treaty. And that started a process in which people began to take that more seriously. It changed people's interest, and it eventually strengthened that law to make it more meaningful than it was when it was initially created in 1985. Another example is Austria with the case of child soldiers. Here was a case in which 17-year-olds actually could legally be involved in combat in Austria. It was possible legally for that to happen. Now, Austria, this wasn't going to be on their agenda, but they were debating their defense bill for that year, and nobody could agree on the defense. should we give the Defense Department? They all agreed, from the far communists to the conservative Christian Democrats, they could all agree that we're going to go along with child soldiers, and they upped their age to 18. They wouldn't have done so if it hadn't have been for wanting to ratify that optional convention. So the second way is enhancing the possibility of litigation. And remember, these arguments are very conditional. This can really only happen in countries that have independent judiciaries. Not all countries do. In some cases, the courts are merely the instrument of governments. And so one would not expect to see this effect in countries where you have politically controlled judiciaries. But it is possible in countries where there's been judicial reform or where the judiciary is known to be quite independent. Let's give it a couple of examples, or two cases I look at. One is the case of Israel. And Israel is a case in which it's extremely easy to access the Supreme Court. Nothing like the filtering system that is here. And many, many, many more cases go to the Israeli Supreme Court and don't get strained out compared to the United States. So Israel ratified the Convention Against Torture in 1991. And then non-governmental organizations strategically used that ratification and as well used the dialogue, because now Israel was required to report to the Committee Against Torture, the oversight, used that as leverage to try to make their case in the Supreme Court, okay, of Israel. So this big increase in the number of cases that go out there. It culminates right around in 1999, the number of cases do, with the so-called landmark case that you may be very familiar with. The case in Israel. Now, here's not what I'm not claiming that the Israeli Supreme Court said, the cat constrains us here. Okay, I'm not saying that. That argument was made, but that's not how they decided the case. But having this additional outside ammunition wears down the court to a certain extent, gets them to think about the broader implications of what they're deciding, and it does actually lead to a very important case that doesn't make torture illegal, they don't rule that they must stop, but that if you want to do these practices that are not consistent with the standards in the international community, you will have to pass a law making them legal. In other words, a positive legislation to make them legal in Israel. Well, that changes the nature of the debate in Israel, because nobody, with the exception of very far right-wing parties, individuals within those parties, nobody wanted to make Israel the first country in the world who legalized torture. So the debate changed. Okay. So that's one example. Another example is the case of Chile. I'm sorry. And here's an example in which you have the ratification of the Convention Against Torture in 1998. Well, why don't things? I mean, I'm sorry, 1988, 89 even. It's right before 19. I think it's in 1989 they ratify the Convention Against Torture. It's actually before this chart begins, but there are no cases before this chart begins. Why? Because it is not until 1998 that two important things happen. Remember, it's a conditional argument. First of all, there's important court reform in Italy. Why am I saying that? In Chile in 1998. Okay? So there's really important court reform, and a lot of the allies of the Pinochet regime are removed from office, and the court is reconstructed to be far more independent than it had been prior to 1998. So now it does make sense to start importing use of the Convention Against Torture into Chile, and we see a big increase. Now, not all these cases actually cite the cat, but many of them do. So we see a big increase in cases, and it becomes an interesting part of the litigation process in Chile. And then, yes?
On the previous slide.
In 1994?
Well, there's... No, sorry, the Chilean slide. In 1994, there was apparently that case which does mention...
Yeah. I don't think like anything happened, but I can tell you where Chile was. They were on their way towards taking steps towards democratization. So Pinochet was out of power. There was an attempt to there were along the way to consolidating on the way to consolidating a new democratic regime. The debate over what to do about allegations of torture and other abuses by the earlier regime is starting to heat up a little bit. But the courts still are not very independent, and they keep slapping these cases away and not. And so you sort of think about, why would I even want to bring a case to a court that I know is not independent? So there's a strategic element here, right? That you're not even going to bring a case if you don't think the courts are independent enough to take it seriously. But I don't think there's anything like in 1994 that can explain one case. That's a blip. But the important thing is, after 1998, with court reform and the example of how we can use the Convention Against Torture with the Pinochet case, with those two things in hand, that becomes a much more powerful instrument when it comes to litigation. All right, and then the final argument I want to make, and I'll make it as quickly as I can, but it's also the most complex argument that I want to make, is the effect that ratified treaties have on the mobilization of groups to expect and demand their rights. So you don't need an independent court to do this, right? But here's a case in which the argument that I want to develop is the focal and normative role that a treaty can play as an intangible resource to groups who want to sort of mobilize to begin to demand their rights. I argue that treaties can actually influence values. They can encourage people who had not thought this way before to think of themselves as rights holders. So women who could not inherit their parents' property, it goes directly to their sons, say, wait a minute, why can't I own property too? These are sort of new values that become introduced when those who, non-governmental actors or other rights groups sort of say, the treaty says something like this. You can start to see yourself in new ways. So it has this educative function. You will recognize this as a constructivist argument, an argument that it can actually sort of change and influence values, possibly even identities. I view myself now as a rights holder in ways I did not previously. It can also increase the chances of success. We've seen it can do that as a legal resource. It can do that, it can make it more likely that you will succeed because it can actually change the size of the coalition now that supports treaty compliance. In the absence of a treaty, you might just have pro-human rights groups. But now, when you have a treaty, you may have not only pro-human rights groups, but pro-compliance groups. That is, groups who think it's important to adhere to international obligations generally. Quite interesting in the Japanese case that in addition to anybody who took a position on women's equal opportunity with respect to labor, you also had bureaucrats in the foreign ministry who thought it was important now to comply as well. Potentially anybody who has got a big stake in how the outside views my jurisdiction may become now interested in compliance in a way that they might not have been in the absence of a ratified treaty. So it increases the chances of political mobilization. Now, people mobilize because it has value to them. That's what I'm arguing here. They mobilize because it's valuable, and if it's costly, it reduces the likelihood they will mobilize. So I think of mobilization as being a combination of the likelihood of succeeding and the value that you place on succeeding, okay? So if I really want something and I'm very likely to succeed, you can be sure I will mobilize. If I'm not sure I want it and it's costly, I will not mobilize, okay? So now, the argument that I want to make here is that in stable autocracies, the value that people might put on mobilization, the value they put on, the likelihood of succeeding, is very low. Because think Tiananmen Square. You mobilize, you get crushed. Okay, so you've got to think about these things. So the likelihood of succeeding is low. In a stable democracy, the likelihood of succeeding if you mobilize is high. It's a responsive form of government. On the contrary, and by contrast, the value you put on succeeding will differ systematically across these. In a stable autocracy, civil and political rights, something I never enjoyed before, for the first time. Freedom from torture, something that it was hard to imagine before. I'll be for that. That's a big deal. Now, those rights are already granted, for the most part, in stable democracies. On the margin, the 100th right, when you have 99, is less valuable to you. Okay, so you don't want to mobilize. You've got better things to do. Have you noticed I'm not out on the streets with a poster saying ratify CEDAW? Because I feel fine about it, right? Okay, so what we have here then is what you would expect here is to see the maximum expected value of mobilizing right in the middle, not at these stable extremes. Okay? So people who run regressions across all countries as though that would make any sense at all are ignoring this mechanism. Okay? So what we have here then is that you would expect mobilization to be greatest in these regimes that are transitioning, where to mobilize really could influence something. Now, what does a treaty do to this? Whoops, here's my argument about what a treaty does. That's just mobilization. Now superimpose a treaty on that logic. And what do you get? Well, I would argue that the value you place on the content of the treaty is greater in a stable autocracy. This goes back to my argument about the educative function and the new identity that you may assume when a treaty is ratified and now your government has said you have these rights. Oh, good, now I appreciate more than ever I might be a property rights holder, or I might be equal to men. Okay, so the value that you would put on changing things would be very high in the direction of the treaty, be very high in a stable autocracy. In a stable democracy, not so much. Here's the difference for me between the United States law and CEDAW, right here. That's the difference for me, But the likelihood of succeeding, again, is the opposite, because democracies are rule of law, typically, and are responsive. Okay? And on top of that, you have all those allies in a real parliament or a real Congress who came out in public and said we support it. So you've got allies. Okay? So in a democracy, you get just the opposite. You get a treaty increases your likelihood of succeeding, but it doesn't change very much. It doesn't change very much the value that you would put on succeeding. Of course, the likelihood of succeeding does not change in a stable democracy much, because courts can't enforce, government's less responsive, et cetera. So this is what you expect for a treaty, is that the treaty effect should be concentrated in these countries, in the countries that are more volatile and transitional, not the stable autocracies, not the stable democracies. I can show evidence of this, and I won't even flick it up for right now because I see time is just about over. But we can see this in a number of different areas. For example, and it's strongest as a pattern with the Convention Against Torture, because the logic is strongest for civil and political rights, really. And so with respect to the Convention Against Torture, using the same definition of torture and the same data even for torture of those who find no effect to the Convention Against Torture, you see fairly strong and convincing effects if you just take out the stable extremes, And so people that are kind of running it on all countries are missing where the action is. The action's in the middle. And we can think of very good reasons why that's the case. It just doesn't change much at those stable extremes. That doesn't mean the treaty's not important. It's crucially important for a large number of countries in the world. Okay? So in the Torture Convention, we can see that. We can see that also in the Convention on Civil and Political Rights with respect to, well, it was hard to see really any effects to fair trial, but with respect to some of the other civil and political rights that I looked at, you could see these same kinds of effects as well. Concentrated, if you just take out the stable extremes, ratifying the treaty has a strong positive result. Now, I changed the indicators but kept the logic when I was looking at the Women's Convention. Here it's not quite so much, despite that I always use the US and it's democratic when I gave you those examples. I argue, remember, that when you have no motive to mobilize because you will simply be crushed, means basically because you will be crushed. You might have a motive but no means, that you will not mobilize. And so what I looked at for the women's case was to have a very, a coalition of established church and or a formal state religion, basically, and a stable formal state religion. And when that was the case, you didn't get very much effect to ratifying the Convention on the Elimination of Discrimination Against Women. Now, interestingly, I then broke it out by religion and found concentrated in Islamic countries and Catholic countries, not in Protestant countries. So Norway has an official state religion, but that's not where the train is being driven. It's being driven in the very conservative cases, Islam and Catholicism, where there is an established state religion. The argument being that there you face a very strong coalition of opposition to women's rights. And it has got a legal foothold in the state as well as a moral foothold in the religion. And that combination discourages much change. So anyway, the argument, that is the nature of that argument. So feel free to interrupt me with any more questions. Bill?
You said that for countries, these conventions are exogenous and that they come from the UN. The UN is a group of countries, and it's a bunch of employees, bureaucrats. Who initiates these things?
Yep.
Is it a country, or does it vary from convention to convention?
It varies a little by
or is it
convention.
bureaucracy?
That's a good question. First of all, I should say when they're exogenous for most countries. There are, of course, spearheads to these various conventions. So, for example, and it's a little bit random as to sort of who exactly, or not random, but it's particular to the history of the country for why they support it. So, for example, Poland was the country that pushed children's rights, really pushed children's rights. And they were in combination with Save the Children. So it's usually a combination of a narrow spearhead of countries, and I'm going to say 3 to 5, that really want to get this going, and a group of non-governmental organizations who agree and want to push it forward. The Convention Against Torture was, early drafts were written by Amnesty International, and then they teamed up with states that felt strongly about torture, and those were primarily, in that case, the Scandinavian countries. So, it's a narrow group of countries that really want to get it on the international agenda. They team up with non-governmental organizations, and there's a ripple out and acceptance from there as debate proceeds, and new versions of and revised versions of the initial draft are increasingly circulated. But it starts reasonably narrow. Yeah. Women, so those are the two that come to mind that I can think of. Who is at the core of those? Interestingly, when the International Covenant on Civil and Political Rights and Economic and Social and Cultural Rights were being negotiated from the Universal Declaration, which was non-legally binding, when it came to sort of turning the Universal Declaration into those first 2 core treaties that were legally binding, the United States opposed, the Great Britain opposed, or didn't want to be on the forefront of any of this and wanted to slow it down. Russia, so all the major powers basically were opposed. This is the 1960s. Were opposed to having a legally binding set of agreements. So often it's not the major powers that want to be at the forefront of this. Often some little country, along with some NGOs, a little democratic country. And there's a whole book on this. I can't think of the citation, but it's about how important the small democracies were to the global international human rights regime. Yes, Larry?
Beth, can you tell me, so we've got at present, a little under 200 countries total in the world, right? So I'd like to know roughly how many countries are volatile or transitional.
Yeah.
I recognize it's a smaller number as you go back in time because you have a smaller total number of countries. But how many, so the most effect is in the middle, but do we only have a handful of countries in the middle?
No.
Large number.
Large numbers, buckets full of countries in the middle. So we have about 200 countries now, but a couple of things. As you point out, we don't have 200 countries this whole period, first of all. The other thing is we don't have anywhere close to 200 countries that we have data on them all. Okay, so we're really running the statistical analysis over 130 to 140 countries. Of those, 70 to 80, I can't remember the exact number, it's about 70 to 80 fall in this transitional category. Because remember, my rule was take off the stable tails. That was my rule. So if you'd never been a democracy, you're in that stable tail. If you'd always been a democracy since World War I, since World War II, take that tail off. Let's look at the middle. And that's a big middle. Half. Yeah, about half. Yeah. So it's a big number and a lot of people.
Yep.
A lot of people. Yes. Oh. Okay. Tim?
You find these striking effects for the difference between civil and common law countries. And the explanation for it seems quite compelling, but I'm wondering how closely is that correlated with the extent to which international treaties have direct effect in domestic law?
What would you say? Well, there's a correlation. I mean, we know, for example, that, so you're sort of getting at the monist dualist kind of a distinction, basically. So we know, for example, that common law countries tend to be dualist. That is, and what that simply means is that when they ratify a treaty, it does not immediately become domestic law. It has to be implemented. So it does take an additional legislative step, and that is correlated with being a common law country. And on the other hand, countries that are civil law more often, not a perfect correlation, but more often tend to be monist. That is, a treaty becomes part of domestic law, often without having to go through the implementation stage. So you would think then that including dualism, which, by the way, doesn't really exist, actually may exist now because of the database on constitutions that Ginsburg and Elkins are putting together. But at the time I did this, there were no indicators of monism and dualism. So, when you think of sort of the comparative law literature, you know that there's a kind of a correlation between those things. But in terms of sort of data, we can't prize it open yet. But I should say, if this interests anybody, there is data now to do that because there's this big constitutions project put together by Elkins and Ginsburg that actually codes, I think, they have things where you could code direct effect and monism and dualism from that. That could be tested. But here's the surprising thing, though, is you would think that if common law countries, since they do have this extra barrier that we can always ratify a treaty but not implement it, you would think they would say, okay, we'll ratify all kinds of treaties, but it's not the effect. That's not what happens. So that's why I don't think it is precisely the direct or non-direct effect variable, because it works in the opposite direction.
We've got a class coming in, but we've got Beth will be outside signing her book, and you can ask questions there. So please join me, and thank you.